Last month, Europe's top human rights court issued a major decision in the fight against climate change. In KlimaSeniorinnen v. Switzerland, the highest chamber of the European Court of Human Rights found that the Swiss government has violated the human rights of its citizens by not doing enough to address the threat of climate change. The decision is a landmark ruling for activists, lawyers, and communities who are trying to use human rights law to hold governments accountable for promises to fight global warming. But it's not the only case asking what international law requires of nations when it comes to protecting the environment. The Inter-American Court of Human Rights, the International Tribunal for the Law of the Sea, and the International Court of Justice are all grappling with similar questions. What do these cases mean for the fight against climate change? Where are the opportunities and the risks? This is the Just Security Podcast. I'm your host, Paresh Shah. Joining the show to discuss the year of climate in international courts and tribunals are Naima Fafita and Joanna Setzer. Naima is a lawyer from Tuvalu who has taken an active role in proceedings by small island nations before the International Tribunal for the Law of the Sea. Joanna is an associate research fellow at the Grantham Research Institute on Climate Change and the Environment at the London School of Economics and Political Science. Joanna, Naima, thanks so much for joining the show. We're so excited to have you here to talk about what's been a really exciting year in climate across all of these international tribunals and courts. So, Joanna, I want to start by talking about the case that's before the International Tribunal for the Law of the Sea. Can you give us an overview of what's been happening there?
This is a request for an advisory opinion that was presented to the International Tribunal for the Law of the Sea. ITLOS is called this tribunal. And what's interesting here is that the request was submitted by the Commission of Small Island States. And these are, as you can imagine, states that are going to be affected and that are already being affected by the impacts of climate change. And what they're asking in their advisory opinion, they're asking that the court, the ITLOS, International Tribunal of the Law of the Sea, considers if states have responsibilities under international law to protect, and this is where it becomes specific, marine environments from the adverse effects of climate change. So this request was submitted in December 2022 and is quite narrow, you would think, especially compared to the other ones, because it's asking about specific obligations in terms of preventing and reducing and controlling pollution in the marine environment and protecting the marine environment, not all environments as the other ones. And this was really the first time that an advisory opinion was sought. We are what's expected, I think that very much what's going to happen. The court already announced that it will deliver its opinion in a public sitting on the 21st of May. So in a couple of weeks, we will be hearing the opinion from the International Tribunal for the Law of the Sea.
Naima, as Joanna mentioned, the ITLOS case has been brought by small island states, and you have long been involved with the coalition that's been working on these cases. Could you tell us a little bit about your work there and how this case came about?
Sure. So as Joanna mentioned, the Commission of Small Island States on International Law and Climate Change was founded on the premise that states who are least responsible for climate change will be the most likely to bear the brunt of its impacts in the short and long term. And so two governments, the government of Tuvalu and the government of Antigua and Barbuda, signed an agreement establishing this commission, COSIS, in 2022, just after the COP26. And now we have a membership of 9 small island states who are all very much involved in both the ITLOS process, but now other proceedings in front of international courts and tribunals, including the ICJ case. And so COSIS's mandate is really to promote and contribute to the definition, the implementation, and the development of rules and principles of international law concerning climate change. And as Joanna mentioned, this is especially exciting because this is the first time an international tribunal is speaking on the relationship between climate change and the protection and preservation of the marine environment and the responsibilities of states who commit internationally and environmentally wrongful acts. So I joined COSIS as a representative of Tuvalu and was able to attend the oral hearings in Hamburg earlier in September with my family to share some of why this mattered to Tuvaluan people, but all island people, and why this advisory opinion mattered to me as a Pacific Islander, as a lawyer, environmental lawyer, and as a mother.
And I'm curious, when you talk to your children about the case, and you also told the New York Times that it's fitting that young people have been on the forefront. It's we who will inherit these decisions that are made before us. What is the significance of this case?
Mm-hmm. Yeah, this case really represents a huge milestone for young people and communities on the front lines of climate disasters. And it has to do with a multitude of factors, but one of them being recognition of the obligation, the legal obligation to protect the marine environment. This recognition provides a strong legal basis for young people and affected communities to hold states accountable for their actions that contribute to climate change. It also strengthens the legal arguments for holding states and corporations responsible for their contributions, and the advisory opinion can serve as a basis for more climate litigation, which can empower young people and affected communities to seek legal remedies for the harms caused by climate change. It brings increased visibility and attention to the issue of climate change and its impacts on vulnerable communities, and this can help mobilize young people and galvanize support for climate action. I think it provides hope and inspiration for young people who are fighting for climate justice and demonstrates that there's a growing recognition of the urgency of addressing climate change, and that legal mechanisms can effectively be used to hold states accountable. Lastly, it really serves as a call to action for young people and communities who are on the front lines to continue advocating for climate justice, and encourages young people to engage in this climate activism and work towards a more sustainable future. So there is some momentum, there's considerable momentum generated by these requests, but also the release, the rendering of these advisory opinions that youth can use as catalysts in their climate work.
Right, and thinking about catalysts for change and hope, one case that wasn't brought by youth, but rather a group of elderly Swiss women, and that's the case that came down before the European Court of Human Rights. Joanna, that's the decision of these 4 sets of cases that we have so far. So what did the court rule in that case?
So that's a very important decision, and we're still trying to understand what the impacts of this decision will be. So the case involves Swiss women and an NGO, KlimaSeniorinnen. What they were trying to do, they were trying to seek stronger action from the Swiss government, wanting the Swiss government to reduce its greenhouse gas emissions in line with what's already in international commitments, in line with the science. So a few important points about this case. First is that before getting to the European Court of Human Rights, the Swiss lady and the NGO, they exhausted all the national remedies available. Why this is important? Well, first, it shows that the case didn't start yesterday. It started many years ago. And that also they lost in all the way to the Supreme Court in Switzerland. So the case before the European Court of Human Rights is their attempt to get the this European Court to re-examine something that they had lost in the domestic court. So in 2020, they bring the case to the European Court, and they say that their health is being threatened by heat waves, and that's being made worse by the climate crisis. They have three main points in their case when they bring the case all the way to the European Court. First, they say that Switzerland's policies are inadequate, so they violate the women's right to life and health, and these are rights that are protected under two articles of the European Convention on Human Rights, Articles 2 and 8. But here you have something important, that the European Convention didn't protect explicitly climate change. It didn't say that it applied to climate. So one of the main challenges of this case was to show to the court that the convention, and therefore that the attention of the court could be put into protecting people from the impacts of climate change. Then second, they said that the Swiss courts rejected the case in an arbitrary way. So that also violates another article of the European Convention, Article 6. And finally, they said that the Swiss authorities and the courts did not deal with their complaints in a way that was adequate, and that also was then being challenged. So altogether, they have the case presented to the European Court, hearings take place, submissions by academics and scientists and other interest parties take place, and finally on April 9th, so a few weeks ago, we get this big decision which no one quite knew what it was going to be. And it was quite groundbreaking in the sense that first, the court accepted that Article 8 of the Convention covers the right to effective protection by the state from serious adverse effects of climate change. So that point that I mentioned, it confirmed. It says Article 8 of the Convention applies to climate change. And then it's also accepted that Switzerland was failing to comply with its obligations. So it really tells off Switzerland, saying you're not doing enough. And that there are specific gaps, and that's super important, because the court says that Switzerland didn't establish relevant domestic regulatory framework. So it didn't have an adequate carbon budget, it didn't have adequate national greenhouse gas targets, and that it also failed to meet its past targets. So it's very specific in what's missing. And lastly, it says it recognizes that national authorities have a discretion, so it doesn't remove from the national authorities what they should be doing. And this is an important question in terms of separation of powers. So it says, well, the policymakers can still do what they want, but it says that what they've been doing so far is not adequate in terms of time, and it's not adequate to stop the potential impacts of climate change. So it asks for more, and it sends it back to the policymakers. So just to finish in terms of what's maybe remarkable there is that there is, of course, it's an important decision in itself, and that's very exciting for lawyers and for legal scholars. It's a precedent that can be used in many other cases. But I like thinking about what beyond the legal precedent, what are the impact, the so what of this decision. And what I find is going to be most important, and it's yet to be seen, is that the 46 states that are members of the convention will have to either update or introduce new climate regulations to meet these requirements made by the court. So this not only means we'll see changes in national legislation and regulation, but also it's potentially going to have a knock-on effect for companies, because you might have restrictions on scopes 1, 2, and 3 emissions. So not just direct but indirect emissions, on reporting obligations. So the impacts are much broader than just what the court means in terms of one decision. It goes in terms of having new regulation, and regulation that can affect not just states but also corporations and other actors.
A lot to watch there in terms of implementation. I remember waking up that morning and seeing all these major news outlets covering the case, and it was cool as someone who follows international law, and exciting to see all the coverage there and the potential that opinion has. There's also a case that's currently pending before the Inter-American Court of Human Rights. So, Joanna, what's happening there?
So that request was made in January 2023, so a few months after the request submitted to ITLOS. And what this one is quite different from the ITLOS one. First, it was submitted jointly by two member states, Chile and Colombia. And what these two states are asking the court is to assess the human rights implications of climate change. So it's focused on what are the obligations of states to prevent significant harm and to safeguard lives, particularly in Latin America and the Caribbean. So the focus here is not, we saw the previous one, the focus was on the marine environment. Here there's a focus on Latin America and Caribbean, and a few also important points in this advisory opinion. So firstly, it asks for a clarification on the scope of states' obligations. So what is the extent to which they are responsible? What are their obligations, both in terms of individual and collective dimensions? So the request includes questions about climate adaptation and the protection of environmental defenders. And these matters had been so far overlooked by other previous advisory opinions that same court have given while recognizing the right to litigate for a healthy environment.
So those are the regional courts and the International Tribunal for the Law of the Sea. There's also a case that's pending before the International Court of Justice. And last March, Vanuatu led this massive diplomatic effort at the UN General Assembly, convincing 130 nations to request an advisory opinion on government's legal obligations in respect of climate change. So, Joanna, can you just start by giving us an overview of the ICJ case?
This is the first time that the International Court of Justice, which is the world's highest court, has been asked to consider the question of climate change. So that in itself became quite a remarkable aspect of this case. It's a new topic for that court, and as I said, it connects to many of the other cases that have been submitted before other international courts and domestic courts. So what a few interesting and unique aspects of the ICJ submission. The request was made by a group of 18 states and led by the small island nation of Vanuatu. So I'm sure that we'll hear more details about this process, but it took, if I'm not wrong, over 3 years for it to be tabled. And in part, this is because there are, for the ICJ, differently from the other courts, the standing rules require that a request for an opinion has to be made by public international bodies, and therefore you need that broad base of support among many member states. As far as I spoke to people involved in the case, they of course hoped, but maybe it was quite a wild dream that you would have 18 states supporting this. So, as you were saying, on March 2023, the UN General Assembly unanimously, which is also quite something, adopted a resolution to ask the ICJ for the advisory opinion on climate change. And this is the broadest of all the other advisory opinions, and it's asking the ICJ to clarify the duties of states to protect the climate system, and here we're not talking about a region or one environment in particular. So here is protect the climate system broadly, and the rights not only of present but also future generations from climate-induced harms. It's also important that this request asks about what are the legal consequences for states that have caused significant climate harm. So potentially this could result in, if established what potential legal consequences for states, it could potentially lead to more litigation, particularly if affecting the most vulnerable communities.
Naima, what is your impression of the case?
Yeah, I think the ICJ case is groundbreaking, in part because of how it started. This initiative started with a group of 27 Pacific Islander law students of the University of the South Pacific in Vanuatu who formed an organization, Pacific Island Students Fighting Climate Change. And they were able to enlist the support of the Pacific Island Forum leaders, including the president of Vanuatu, youth partners from around the world, and form an alliance of more than 1,500 organizations working at the grassroots, as well as larger international organizations. So I think this really highlights the potential of young people in mobilizing, contributing to the development of international environmental law. And I think, other than that, Joanna has done a beautiful job summarizing this advisory opinion, and I think that's all I would have to add, just emphasizing the role that these frontline communities and young people were able to play in this process.
How might the cases that are currently pending before these other international bodies, how might those affect the way that the International Court of Justice is thinking about these questions?
Yeah, I think for one thing, it provides precedent and the opportunity for legal consistency. So previous cases and advisory opinions on climate change-related legal obligations can set precedents and establish a body of international law. And the ICJ may consider these precedents when making its decision, as they provide guidance on interpreting and applying relevant international law. It also provides cumulative evidence and support, and so multiple cases and legal proceedings on climate change can contribute to a growing body of evidence and support for the recognition of states' legal obligations. And the ICJ may take this into account, demonstrating a convergence of views and concerns among various countries and legal bodies. I also think climate change it's still relatively new and evolving area of international law. And the ICJ will need to account for how other cases have contributed to this development and the clarification of legal principles, which would reflect this evolution, the evolutionary nature of international law. And the ICJ can also examine how states have responded to and implemented legal obligation outlined in previous cases or advisory opinions. It's not immune. The ICJ isn't immune to political and diplomatic considerations either, and the number of countries supporting the Vanuatu-led case and the broader international context, including ongoing climate negotiations and discussions, may influence the court's decision. So overall, while the ICJ's decision will ultimately depend on its own interpretation of international law and the specific arguments presented, other cases can substantially contribute to a more comprehensive understanding of the legal obligations of states regarding climate change. So we'll have the rendering of the advisory opinion from ITLOS on May 21st, and the ICJ will, I'm sure, be cognizant and aware of what that opinion establishes.
It's an interesting moment because you have all these proceedings that are pending. We have an idea that now ITLOS will come first, and it's not obvious how one is going to impact the other. We hope that the courts will reading and considering, and that you won't have a complete mad patchwork of different decisions. At the same time, they could if they wanted. So I think the implications are still very much, we're trying to imagine, it's all yet to come. But something important to keep in mind is first that they are non-binding. So no state or court is required to follow what's there. At the same time, they, and this is mostly what you read in commentaries and experts' analysis, is that these, whatever, especially the ICJ, but the other courts will say, has legal and moral weight. So there is a weight that is not necessarily that of a law, but there is a legal and moral weight. And that could spur governments towards more ambitious climate action, and it could offer some direction or an idea of language for advocacy and for other cases. So I think that this is a point that our colleague Rebecca Hamilton, who I think is the one who's put us together here, she's a professor at the American University at Washington College Law, and she argues specifically that there's this collective outcome that you might see coming from the cases, and that would provoke an articulation of states' commitments. So it brings together what states should be doing. And particularly the ICJ, it could have more of this broad impact in making clear what that nations that contribute to harm in other countries have a duty under international law. And this would be quite important, that they have to cease, they have to alter their activities. And this is a message that I'm sure would be picked quite by many litigants and organizations. But I think it's also important to keep in mind that there are others that are criticizing and maybe raising questions about potential dangers of these advisory opinions.
So what are some of the risks or drawbacks to bringing these cases and seeking these decisions?
You have scholars saying that these could be too vague, and that they could create a situation where state sovereignty feels attacked, or that complicates climate negotiations. So that's something I've read. I've also read that there's this risk of a cacophony of different opinions. So, of course, there is an understanding that they could be very important in mobilizing and bringing unity and increasing ambition. But also there is a certain consideration or concern about whether it could be unhelpful, especially for the climate movement, if you have the ICJ, for instance, closing doors. So it will be, I guess, a balance between what the different courts are saying, what can be, and how that can be communicated in an accessible way beyond the courts, and how other litigants might use some of those decisions and opinions in future litigation.
Naima, do you have anything to add on that?
I mean, maybe if we're looking at climate justice, not only from through the lens of outcome, but also process, there all international legal proceedings can be very complex and time-consuming, and climate change litigation is, of course, a highly complex issue with many contributing factors, and this makes it challenging to navigate the legal processes effectively. Moreover, legal cases like these can take years or even decades to resolve, and this can potentially delay urgent action on climate change. There's also resource constraints, and pursuing legal cases at the international level can be resource intensive, requiring significant financial, legal, and diplomatic resources. And this can pose a real challenge for countries, developing countries, and marginalized communities who may have limited access to such resources. Joanna mentioned the uncertainty of outcomes, and this is more on the outcomes side of the spectrum, but the outcomes of legal cases on climate change are uncertain, and they can be influenced by various factors, including the interpretation of international law, the composition of the court, and political pressures. And so this uncertainty can make it difficult to predict the effectiveness of legal action in achieving desired outcomes. I think the topic of lack of enforcement mechanisms has been covered. International courts and tribunals generally don't have the power to enforce their decisions. While their rulings may carry moral and political weight, of course, they may not be legally binding on states, and this can just limit the effectiveness of legal decisions in bringing about tangible changes in climate policies and practices. And I suppose we'll touch on this later when we discuss enforcement, if we do continue to that question. But this is one of the potential hurdles we may see states encounter as they grapple with at least the ITLOS advisory opinion.
When it comes to international law especially, where the rubber hits the road is really around enforcement and implementation. So what are some of the challenges and the opportunities here around enforcement and how states understand their legal obligations?
Yes, the implementation and enforcement of international law at the domestic and local level is always a tricky issue to address, but these international decisions are what I see as the starting point, in that they clarify obligations for those countries committing international environmental wrongs. And they set a vital standard that has the potential to protect the resources and environments that so desperately need that protection. And it's a standard that governments will be forced to at least acknowledge and be cognizant of. And we know that soft law in international law, environmental law, plays a crucial role in several ways. It can serve as a catalyst for action by raising awareness, mobilizing stakeholders, and encouraging voluntary compliance. And it can create a sense of a momentum and an urgency around environmental issues. It can facilitate dialogue and cooperation among different stakeholders, including governments, businesses, civil society organizations, and local communities. And it can really provide a platform for sharing best practices and experiences. These advisory opinions can also help build consensus on emerging environmental issues where there is no clear international consensus, or where negotiations on binding agreements are protracted. It can create a common understanding and shared principles. And it can influence the development of hard law instruments such as treaties and conventions. It can provide a foundation for negotiating binding agreements and help really shape their content. I think these advisory opinions address complex environmental issues that are not easily captured by traditional legal instruments, and can provide a framework for addressing issues such as climate change or biodiversity loss and sustainable development, and can promote compliance with environmental obligations by providing guidance and encouraging self-regulation, and create a sense of accountability and moral responsibility. So overall, soft law in environmental law is a really valuable tool for addressing these complex environmental challenges. And while it may not have the same legal force as binding treaties, it plays a significant role in shaping international environmental governance and advancing sustainable development.
Maybe I can step in just to add a tiny point, because Naima covered really so well this question. And I agree, particularly when she said that these are a starting point. and at the same time, they might have a role in shaping international law. So I think the 2 points that I would add, and this is work that I'm based on work that I'm doing with 2 colleagues at the LSE, 2 international relations scholars who, of course, understand much more from the international side than I do. And what we were discussing is that in addition to these effects on courts and jurisprudence, and I think there are 2 interesting additional effects that these advisory opinions might have. One is on the role of science and evidence, especially as we're talking about climate change. I think this is quite specific about these advisory opinions. And by this, I mean that there's an opportunity there to consolidate and bring legitimacy to scientific evidence. It's often a hurdle, a challenge at least, for litigants to decide what evidence to bring in their cases, how to communicate that evidence to the courts. There are so many studies, there are thousands, there's of papers, there's the IPCC report and several IPCC reports. So what evidence you bring, how do you communicate that science is always a challenge. So one thing that these advisory opinions, I think, are potentially doing, and that is very helpful, is consolidating that science. And I'm curious to see how the courts are going to deal with this amount of information, often information and a language that they are not so used to. And then finally, it's a point that Naima made already, which I think we can't underestimate, which is the power of advocacy and mobilization that these advisory opinions have had already. Just bringing together dozens of nation states, small islands, and lawyers from around the world, scientists, NGOs, academics. It's really extraordinary to see in just by looking at the different submissions that have been made. If you look, and I got to that exercise of trying to count how many submissions have been made and how many people are participating of the hearings when they are being offered, it's really extraordinary. And often you have all these experts, they're doing that without being paid extra. They're really dedicating a lot of time in writing and presenting their ideas, reflections to the court. And even outside of these written submissions, the movement that this is creating, the thinking that is being put around these submissions and these cases, I think that this is not going to be lost, and that even in terms of a new generation of researchers, of lawyers, you're forming all of this new generation with really a very rich experience that they will be able, hopefully, to transfer in their careers and into future work, not only in litigation. Hopefully it's not just all going to go into litigation, but in thinking about policies, in implementing policies. So just finishing, it's about what we're talking, the challenges of enforcement. The challenges of enforcement are not limited into the litigation. They should be really thought in terms of how do you design better policies? How do you implement better policies? And my feeling is that a lot of the work and effort that has been put into these advisory opinions by experts and lawyers will hopefully be transferred in the domestic level in implementing and enforcing policies.
Yeah, there's so much that provides opportunities for the next generation of lawyers and researchers, as you said. Is there anything that we haven't mentioned yet that you'd like to discuss?
Maybe just the last tiny note, just more on a philosophical level. I think one thing I might add is just that, what we're seeing in these international courts and tribunals really underscores the fundamental truth that humanity's collective experiences are shared, and this necessitates a comprehensive representation of diverse perspectives at every level of governance for effective responses. And the times of turbulence in particular present profound opportunities to redefine our collective values and underlying assumptions. And the challenges posed by climate change should really catalyze the adoption of inclusive governance practices and equitable community living patterns that can unlock the full potential of the human experience. And I think, when we're looking at climate change litigation or climate change and other major crises in the world, they compel humanity to recognize its oneness and its singular existence, and therefore its need for new patterns of organizations that are commensurate with today's needs. So I just wanted to share that, because I definitely think that this is a revolution of sorts. What we're seeing in these courts is a reflection of humanity's awareness of its interconnectedness, its sense of justice, and hopefully there will be an adequate response to that.
We'll be following all of these cases at Just Security. Joanna, Naima, thank you again for joining the show.
Thank you very much, Paras. It's been a pleasure, and looking forward to having more conversations with you in Just Security.
Thank you so much, Paras, for having me. It's been an honor to share this time with you and Joanna.
This episode was hosted and produced by me, Paras Shah, with help from Clara Abt. Special thanks to Naima Fafita and Joanna Setzer. You can read all of Just Security's coverage of climate change, including analysis of the international law dimensions, on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.